Start. The writ petitioner therefore, has to exercise due diligence to bring on record all pleadings and evidence as has been held by the apex court in the case of Bharat Singh and others versus State of Haryana, within bracket 1988 bracket out 4 SCC 534 staff. The relevant extract of paragraph 13 of the said judgment is reproduced herein under para code. In our opinion, when a point which is ostensibly a point of law is required to be substantiated by facts, the party raising the point, if he is the writ petitioner, must plead and prove such facts by evidence which must appear from the writ petition, and if he is the respondent, from the counter affidavit staff. If the facts are not pleaded or the evidence in support of such facts is not annexed to the writ petition or to the counter affidavit, as the case may be, the court will not entertain the point staff. In this context, it will not be out of place to point out that in this regard there is a distinction between a pleading under the Code of Civil Procedure and a writ petition or a counter affidavit staff. While in a pleading, that is, a plaint or a written statement, the facts and not evidence are required to be pleaded, in a writ petition or in the counter affidavit, not only the facts but also the evidence in proof of such facts have to be pleaded and annexed to it staff. So, the point that has been raised before us by the appellants is not entertainable staff, but in spite of that, we have entertained it to show that it is devoid of any merit staff decode para. The writ petition, however, should not be thrown out if the petitioner, in spite of exercise of due diligence, is unable to procure the document under challenge staff. A writ petitioner, however, has these days is facilitated with all electronic devices having sufficient means to procure orders, notifications or the like that are under challenge that are made available online or through internet services or websites staff. Even otherwise, the provisions of the Right to Information Act 2005 are available for procuring such information, and thus, the filing of writ petitions should be complied in all respects, but at the same time, this court is not denuded of its power of entertaining a writ petition and calling for the records of proceedings that is prayed for quashing staff para. The view expressed by the learned single judge therefore, cannot stand the scrutiny of law staff. The appeal therefore, deserves to be allowed staff. The appeal is accordingly allowed staff. The impugned judgment dated 7th December, 2012 is set aside staff para. The writ petition shall stand restored to its original number and shall be considered by the learned single judge on merits on the submissions advanced by the parties concerned staff para. Let the writ petition be listed before the appropriate court in the next cause list staff.